Alright, Chapter 11, Listing Buyer Agency Agreements. Essential matters to learn in this chapter: listing contract of employment between the broker and principal of the property owner. Listing comes under the law of the agency. See Chapter 4, Fiduciary Duties of the Broker. Listing agreement that obligates the owner to pay for the broker commission whether the broker brings ready, willing, able to buy, or willing to buy a list of terms. The most states listing must have the writing have the fixed expiration date, generally returns between 60 and 120 days. Broker must leave a copy of the listing with the owner immediately after it's signed. Listings that belong to the broker, even when procured by a salesman, although the particular salesman may have precluded the listing when the salesperson leaves the employ of the broker, listing remains the property of the broker. Major types of listing include open. The owner reserves the right to engage additional brokers. One who sell the property earns commission. This is often even the commercial property. Exclusive agency, where only one broker may earn the commission. The owner can sell and buy his own efforts without paying a commission. Exclusive of the right to sell, the broker gets commission for the sale no matter who sells or include the owner. Net, the owner receives the stated net amount of the sale, but the broker keeps the expense for the price over the sale of the net amount as a commission. Net listings are illegal, unethical, and depending on the state. Multiple listing, the broker has a listing share of the commission is a sale of the competitive broker who brings the purchase. Limited service of the broker provides limited service over the owner and buyer, usually at a fixed fee. Such services may include helping a seller buyer complete a contract sales form. Listing prices established by a property owner, often market information provided by a broker. Rate of commission specified in the listing and negotiated with the owner. Fixed commission set by the different brokers in the local market are prohibited by Sherman antitrust law because they are anti-competitive. Listing brokers collect the commission at closing. The broker shares or splits the commission with the salesperson procured. Listing with cooperating brokers who brought the buyer. Buyer agency agreement occurred with the buyer agreed with the representative of the broker who seeks the suitable property official fiduciary to buyer. Dual agencies occur with the same broker representing both parties. All parties must be aware that the arrangement agreement exists. Understanding the broker cannot pay loyalty with the both parties. Broker may require a different salesperson with the same representative of the buyer and seller. Designated agency bring the separate broker to assist party in sale instead of having both broker and representative with the same firm. Transaction broker occurs when the buyer is sold with the ask of the buyer provide certain service. Even though newly interested broker did not bring the party who is either the buyer or seller. The termination of the listing occurs with two distinct categories by the parties of the operation of the law. Termination by parties' performance of the property sold. With mutual consent, both parties agree to terminate. Expiration time using period expires. Revocation of principal may revoke but may owe commission. Revocation by broker may revoke but may be liable for damages. Termination by law. Death of the either party, bankruptcy either party, insanity of the either party, destruction of the party. Be studied with Chapter 4 Agency Law, Chapter 20 Fair Housing Law. The listing is a contract of employment between the principal of the property owner with the agent broker for the sale of the lease of the real estate. Under the terms of the listing contract with the principal, agree to pay the broker commission when the broker locates a party who is ready, willing, and able to buy the lease of the listed property at the list price. Should an offer tendered for less than its list price, the broker is entitled to a commission of the transaction consolidated. The listing is owned by the broker, not the salesperson who procured a different kind of a contract between the real estate broker and his or her client. Buyer agency agreement. Usually don't call them listings, therefore, though, because the term listing has always referred to the property sale. Normally, the seller pays the commission in closing possible if the buyer agree with the party commission in lieu of the seller at additional seller loans the party as aware of the circumstances. Type of listings. Listings can be categorized 6 broad types as follows. Open listing, exclusive agency listing, exclusive right to sell listings, net listings, multiple listing service or MLS, limited service listing agreement. Each type is described below. Opening listing, even an open list principal offers of the broker commission provided by the broker secure for the purchase of the owner and receive the right to list the property with other brokers to the sale of the property himself. Thus, open listing is open for other real estate brokers. All open listings automatically cancel upon sale of the property, so the seller pays no more than one commission to one broker. However, the owner gave the exclusive listing to the broker, also gave an opening listing with a different broker, produced a buyer. The owner is liable to commission both brokers. Exclusive agency listing. Exclusive agency listing with one of the brokers employed with the exclusion of all the other brokers. The owner retains the rights to sell the property or sell it without paying a commission. However, if the property is sold to the broker other than the listing broker is still entitled to a commission. 3. Exclusive rights to sell listing. Exclusive right to sell listings allow the employed broker to collect the commission upon sale, no matter who sells the property, whether the employed broker, another broker of the owner procures a purchase broker. Exclusive right to sell again the fee of it is upon sale. At first glance, such contract may seem in the seller's disadvantage, even if the seller procures the buyer of it or her own. Another broker finds one a listing broker earns a commission. However, the rigid arrangement gives the listing broker the assurance of that the property is available for sale by him only. Brokers employed with the other type of listings may be dismayed. Learn property has been sold to the owner and other brokers, since that does not occur with the under exclusive right to sell. The employed broker has no more incentive to devote his or her efforts to spend money to promote the sale of the listed property. Recognition of the fact most real estate boards emphasize the exclusive right to sell listing, particularly in single-family dwellings. For net listings, net listing property owner fixes the amount that he wishes to receive from the sale, informs the broker. For example, he wants a $175,000 check from the sale. Of the broker may keep the amount with the commission so long as the seller nets $175,000. Listed for the sale price is $175,000 and one. The commission is $1 a sale of $190,000 yield of $15,000 commission. Generally, net listings are held repute in the real estate broker business. Many states are illegal, in other words, frowned upon, otherwise just encourage licensed officials. The reason is that they offer many opportunities for unscrupulous brokers to violate agency relationships with the principals, owners who list their properties with them. Owner who isn't knowledgeable about actual value of the property could be talked into a net listing a property low price, thereby all guaranteed. The broker usually high payment for selling property for listing prices. Reasonably broke may try to hide, may illegally turn down offers of the owner properly who would accept but do not provide enough excess for what broker thinks adequate commission. Example, the property is not listed at $200,000. Obviously, the owner will take an offer at $200,000 or more, unless the listing assures her receiving the full $200,000, but no more. Any offer at least $200,000. A broker who receives an offer at $200,010 may consider a $10,000 share through the title. Too little, be tempted to try his own negotiated higher price, turn off offer down, delay transmitting it offer, otherwise violate the obligation under license law, immediately transmit the offer to the owner. In the states that permit net listing, authorized professional real estate brokers associations suggest that when offering a net listing, the broker add a customary charge to the net amount, then inform the seller of the resulting listing price. For example, 6% commission rate added to $160,000. That figure results in $170,212.76. Offering price 6% of $170,212.76 is $10,212.76, leaving $160,000 for the seller. The arithmetic works as follows. Net amount to the seller over the fraction sales price to the seller equals list price with commission. 5. Multiple listing services, or MLS. In many metropolitan areas, most brokers agree to pool all their listings in the form of a multi-listing service coordinated activities, though the broker agrees to share the exclusive rights to selling listing. Any cooperating broker may sell the property to another has listed upon sales of multiple multi-listed properties, or MLS. Commission is split in with the listing selling broker in accordance with the agreement established for the multiple listing service. Members pay the fee for the service to cover expense and operation, which include periodic publication in writing or made by computer, and other features are listed of the property of the broker belonging to the multiple listing service. 6. Limited service listing agreement. A limited service listing agreement is the seller agrees to pay the broker. Other payment is flat fee in advance for the non-refund. The broker agrees to perform certain services, such as inclusion of the house and multiple listing services will inquire directly to the seller rather than the broker. The seller may agree to pay commission, typically 2 to 4% of the buyer's licensed representative. The seller may, for an additional, typically pay the closing. Having the listing broker and provide seller representation services generally under the agreement. The owner may sell to the buyer or she procures without paying a commission. Selecting a form. No special form is required for the listing. However, it is important to read the form and use without getting to understand the type of listing. Agency law. A broker and agent for his principal, the broker, duties, obligation, responsibility is principal covered by law. Agency chapter 4 of the book describes the body of the law with the pertaining to the real estate broker. The main statement that required of the upon the first contact with the prospective buyer, broker, sales profit, may describe the prospect agency relationship with the seller, if there is one, ordinarily accomplished by having the buyer sign and then return the agent form, or easily designed prescribed by law with the describe of the agency relationship, so the prospect understands which party agency owns Whereas loyalty brokers can represent the buying negotiation transaction. In some cases, the agents of the buyers and so there be agents in contract between brokers and buyers. Disclosure is required here too. When negotiation begins with the seller or the seller's broker of the property buyer is interested in the seller or listing broker must be notified of the buyer-broker agency relationship. Rate a commission in the matter of law. Commission rates of the sale of the real estate negotiated between the principal and his broker. The rate amount should be specified in the listing contract and avoid misunderstanding. Standard commission rate. The local area violates Sherman antitrust law since non-competitive. Listing period. Contract list real estate should have a fixed expiration date. Many of the contract provide 60, 120 days for the sale of the single-family home, 6 months for a year for the commercial property. Apartment complex laws do not establish limits to actual period of agreement upon matter of negotiation. Occasionally, after having shown the particular piece of property through a broker, and a prospect property owner may arrange behind the broker's back. Together, they wait for the listing to expire the contract of the sale without advising the broker in an attempt to elude the payment of the commission. Despite the fact the listing has expired, courts are likely to require payment to the licensed broker whose listing expired. If he can show that she was procuring cause of the sale, meaning listing containing provision that protects the broker in situation. A broker protection clause specifies that the broker is entitled to the commission when the prospect is introduced buys property after listing has expired. Extended clause have been continuing certain entire listing automatically after expiration date. However, this is considered violate requirement of listing that a listing have a fixed termination date. In many circles within recent years, the extended clause has functioned in similar manner to broker protection. Buyer agency agreements. Agents and real estate brokers does not just represent the seller in the listing contracts, they also can represent buyers when they do. The broker and the buyer execute the buyer agency agreement. The contract of obligation for the broker to represent the buyer, the lookout for the buyer, the interest of the buyer agent of the broker, sales rep can point out the other property that might be better suited with the buyer's needs, can stay with the given property, may be overpurchased, can otherwise survive, with the assist of the buyer to get best possible property to suit the buyer's need for the best possible price. As a listing broker and salesperson should not offer the kind of assistance potential buyer because it would violate the agency's obligation to sell the created listing contract. Meaning the buyer agency agreements are exclusive. That is, if the buyer agrees to employ with another broker during the term of the buyer agency contract of the particular concern is how buyer's agent will be paid in traditional real estate brokerage. All agents are paid out with a receipt of the commission paid by their seller to his or her listing broker. Almost anywhere in the United States, buyer agency work the same way today. Listing contracts typically stipulate that the seller will allow the buyer's agent to be paid from proceeds for the commission from the seller will pay. The buyer's agency contract usually say this, however, the buyer's broker will be paid. However, the buyer agency contract describes the payment that the buyer must make. The buyer receives out of the ordinary kind of services from the broker. If the buyer decides to buy the property under a listing contract that does not allow commission sharing with the buyer broker. Buyer agency agreements have become popular, and this reason is obvious. They give buyer access to the same level of advice and expertise the sellers have traditionally always had for their brokers. Buyer agency agreements are subject to the same agency law provision. Listing contracts may be determined in the same way. Described with the listing contract, buyer agency agreements are also have them limited to 60 to 120 days if typical. Should you read your state license laws carefully to find out exactly how your buyer agency treated and the rules regulations apply to it. Dual agency transaction brokerage. Dual agency or transaction brokerage, special case for the agency. Dual agency licenses represent both buyer and seller at the same time. Transaction brokerage, some states call it the facilitated brokerage. License works for both seller and buyer. Responsibilities for either party are limited. In some cases, the transaction brokerage is treated as no brokerage agency. Dual agency creates a potential conflict because it's impossible for the dual agent to provide full agency responsibility to both parties at the same time. Therefore, the dual agent contract certainly restricts actual agency responsibility that the dual agent has. Typically, dual agency cannot tell the seller maximum price of the buyer is willing to pay, and cannot tell the buyer the minimum price the seller would accept. Nor will the dual agent tell either party about the particular urgency to transact or lack of it, and the other party may have. Essentially, dual agents pretty much prohibited from giving either party advantage. Transaction brokerage. Transaction brokerage generally engage in provided limited representation buyer and seller. This allows the license to assist both of the buyer and seller. The licensor will not work to represent the one party to determine the other party which acting transaction broker with both parties to do the transaction, which some states are disclosed in residential transactions as follows: dealing honestly and fairly, accounting for all the funds, using skill, care, diligence, transaction, using all the known facts of the material effect of the value of the residential property and not readily observable to the buyer, presenting all off the counter off the time and manner when left the party has previously directed with the license, otherwise writing limited confidentiality unless waived for the writing by a party limited to confidentiality, prevent the disclosure of the seller except for the price less than the excess listing buyer. Buyer will pay the price greater for the price submitted. The writing offer for the motivation, aim of the priority of the selling of the buyer property. Seller or buyer will agree to finance terms other than those offered, and any other information requested by the party remain confidential. In addition to the duties entered within a separate written agreement, it should be noted that loyalty, confidence, obedience, and full disclosure are not included in the transaction broker relationship. The seller or buyer is considered to be a customer of a broker and not a principal. Customer is responsible for the acts of the broker license. The transaction broker sometimes does not establish agency relationship at all, but the transaction broker is subject to the same restrictions dual agent regarding information either the seller or buyer. The only responsibility the transaction broker has is either party does not to make a mistake, and when he does, for them to exercise due diligence in when he does what he does. Essentially, the transaction broker handles the paperwork, provides the buyer access to lists and properties, introduce buyer and seller, supervised negotiation that does not offer to advise for the price for the term of sale, the sort of thing lies up to the buyer and selling themselves with the other information they need to conduct negotiation. Buyers struck your state laws very carefully. See allows either dual agency must do with it or transaction broker may do or not, many don't, but increase the popularity for whichever or both is allowed to make sure that you understand the state restriction rules regarding them. Alright, designated agents. You found look to see if there's a state allowed with a designated age for the new 21st century innovation that's supposed to solve the problem with the curb of the licensors have with the buyer agency agreement. The buying prospect wants to show the prospect of a house, which is also she listing contract seller agency would create with a dual agency situation with both parties. The lot agency representation benefit the destination agency set with allows lets licensing manage brokering assign one side of the transaction is different. Agreement agent with a firm. This means one of the parties suddenly finds himself working through with a different agency as long as the interest in a particular property. However, the agent can give the full agency representation. The other party can get full agency representation from the original agent. Typically, the buyer would assign with a designated agent. This can't happen though without an assigned party's consent. The consent may be written with the original agency contract listing or by an agency agreement. The permission may be obtained with the time designated agency occurs. Termination of listing agreements may be determined either by a party or operating law of the termination of the parties through the form of the broker. Purchase of the broker procures the purchase. Listing contract is terminated when the sale is completed. Mutual consent. Both parties agree to terminate the listing. 3. Expiration with agreed time. Listing generally the definite expiration date. If it does not, listing ends the responsible period. In many states, the listing must have a fixed expiration date. For revocation by principal, any time when the principal may revoke the authority given by the broker, however, the principal may be liable to damage resulting from the breach of the contract, but it now can show that the agent has negligent, introducing disloyal, dishonesty, and incompetency. Revocation by the broker, agent terminates the listing contract, abandoned, however, that may be held with the damage to the principal because of the failure to complete the object of listing contract. Termination by law can occur with the death of either party. With the death of either principal or other party, broker generally causes the termination of listing contract. Bankruptcy, either party bankruptcy of the principal or agent normally terminate the contract. Insanity of the other or either party, either party judged to be insane is considered incapable of completing a contract. Therefore, the listing contract will terminate. Destruction of the property. If the property upon the agency had been created to destroy, the agency is terminated. Question 11, Chapter 11. Chapter 12, Other Real Estate Contracts.